Mr. President, members of the Court, it is an honour for me to appear before you in these proceedings and to do so on behalf of the Kingdom, the United Kingdom of Great Britain and Northern Ireland. The United Kingdom welcomes this opportunity to emphasise its support for the role of the Court, for the United Nations and for international law. Let me reaffirm at the outset the United Kingdom's condemnation of Hamas for their outrageous actions on the 7th of October 2023 and their ongoing threats to Israel. Their hostages have endured and continue to endure unimaginable cruelty. We call for the immediate and unconditional release of all hostages. The United Kingdom has consistently urged Israel to ensure access to humanitarian assistance in accordance with its international obligations. In a speech on the 20th of March 2025, the Foreign Secretary made it clear that the United Kingdom was resolute in calling on Israel to abide by international law and to lift the unacceptable restrictions on aid and demand the protection of civilians. The UK's announcement of the suspension of arms export licences on the 2nd of September 2024 was underpinned by the clear risk that certain military exports to Israel might be used in violation of international humanitarian law, an assessment that was based in part on Israel's restrictions on the provision of humanitarian assistance. On Tuesday this week, the Foreign Office Minister of State addressed the UN Security Council. He called for a return to the ceasefire to end the relentless death and destruction that Palestinians face daily. He stated, and I quote, "It is unacceptable that Israel has blocked humanitarian support from entering Gaza for nearly 2 months, meaning that Palestinian civilians, including 1 million children, are facing starvation, disease and death. UN and other workers must be able to deliver life-saving assistance safely and in line with humanitarian principles. Mr. President, Israel must facilitate full, rapid, safe and unhindered humanitarian provision to the population of Gaza, including food, water and electricity, and must ensure access to medical care in accordance with international humanitarian law." The United Kingdom voted in favour of Resolution 79232 in line with its strong commitment to international rule of law. Our vote in no way detracts from the United Kingdom's commitment to Israel's security or its commitment to negotiations between the two parties towards a two-state solution. Only the achievement of that goal will put an end to the continuing humanitarian tragedy. Mr. President, members of the Court, the United Kingdom is of the view that the Court has jurisdiction and that there are no compelling reasons not to give an opinion. We wish, however, to stress the importance of the principle that a state is not obliged to allow its disputes to be submitted to judicial settlement without its consent. We urge the Court, as it has often done, to reaffirm that principle of consent. Having said that, rendering the present advisory opinion would not, given the terms of the question focusing on obligations, circumvent that principle. This is particularly so since the United Nations has a direct and special interest in this case. Mr. President, I would request that you now invite Sir Michael Wood to the podium to address certain questions of United Nations law, and then following Sir Michael, I shall return. Thank you, Mr. President.
I thank Ms. Langrish. I now invite Sir Michael Wood to address the Court. You have the floor.
Mr. President, members of the Court, it's an honour to address you and to do so on behalf of the United Kingdom. I shall first say a few words about the question before the Court. I shall then address the obligations of Israel as a member of the United Nations. I make 4 points about the question. First, the question asks about the obligations of Israel as an occupying power and as a member of the United Nations. While it does not ask about the obligations of any other actor, the question is framed in general terms, and at least in some respects, the Court's response is likely to be relevant to the obligations of all members of the United Nations and to the obligations of all occupying powers. Second, the question is limited to the obligations of Israel. It does not expressly ask about the rights of Israel, in particular its right of self-defense. But any answer must have regard to Israel's rights. In addition, and as noted by the Secretary General, the focus of the question on the obligations of Israel does not prejudice in any way the obligations of other relevant actors such as Hamas. Third, the question does not ask about violations. It has been suggested by a number of speakers that the Court should address questions of state responsibility. But in our submission, to do so would distort the question for which states, including the United Kingdom, voted. Fourth, the question covers a wide range of United Nations bodies, as was well explained in the Secretary General's written statement. Mr. President, members of the Court, I now turn to the obligations of members of the United Nations under various provisions of the Charter, in particular Articles 104 and 105, as well as the obligations under the 1946 General Convention on the Privileges and Immunities of the United Nations. On Monday, the Distinguished Legal Counsel of the United Nations set out the position with great authority. Mr. President, members of the Court, we agree with the UN Legal Council on the importance of states fully respecting their obligations concerning the legal capacity, privileges and immunities of the United Nations, so as to enable the organs of the United Nations to fulfill their mandates. Compliance in good faith with Articles 104 and 105 of the Charter and the General Convention is of the greatest importance for the effective functioning of the United Nations throughout the world. Before turning to some of the obligations of UN member states under the Charter and Convention, I must mention the obligation of the United Nations to cooperate with the host state. Section 21 of the General Convention provides that, and I quote, "The United Nations shall cooperate at all times with the appropriate authorities of members to facilitate the proper administration of justice, secure the observance of police regulations, and prevent the occurrence of any abuse in connection with the privileges, immunities, and facilities mentioned in this article." In this context, it's important also to recall Article 100 of the Charter, which states that United Nations staff shall not seek or receive instructions from any government or from any authority external to the organization, and they shall refrain from any action which might reflect upon their position as international officials responsible only to the organization. As others have said, under the General Convention, the United Nations enjoys immunity from every form of legal process, immunity for its property, and perhaps most importantly for present purposes, its premises are inviolable. UN officials are immune from legal process in respect of words spoken or written, and all acts performed by them in their official capacity. As stated on behalf of the Secretary General, the privileges and immunities owed to the United Nations are applicable to UNRWA, a subsidiary organ of the General Assembly, and must be respected at all times. Mr. President, members of the Court, I now turn to Article 2, Paragraph 5 of the Charter, to which a number of participants have referred. It is not clear that, in the present context, this very general provision adds anything to the more specific obligations applicable to Israel as an occupying power and as a member of the United Nations. It may not be necessary on the present occasion for the Court to delve into the questions that have been raised concerning the scope of Article 2, Paragraph 5. The cooperation at issue in the present case is more easily covered by other provisions of the Charter and IHL. If the Court were, however, to find it necessary to refer to Article 2.5, it may wish to exercise some caution. This, I think, seems to have been the approach of the UN Legal Council on Monday. I should recall that on the relatively rare occasions when Article 2.5 has been invoked, this has usually been in very general terms. As early as 1949, in the Reparation for Injuries advisory opinion, the Court considered the need of protection for agents of the organization, and in that particular context, stressed the importance of the duty to render the organization every assistance. As you are aware, members of the Court, Article 2.5 has two limbs which are closely related. Under the first, all member states are required to give the United Nations every assistance in any action that the United Nations takes in accordance with the Charter. Under the second, all members are required to refrain from giving assistance to any state against which the United Nations is taking preventive or enforcement action. Should the Court consider it necessary to address Article 2.5, the United Kingdom's position is that the first limb applies only to action taken by the Security Council. If Article 2.5 were to provide for an obligation to render every assistance to any action in a wider sense, that would impose unspecified and potentially unlimited obligations on members. It would call into question the carefully defined system of competences of the principal organs as laid down in the Charter. The Court has heard from some participants the view that even recommendations adopted by UN organs are binding on member states, and towards the implementation of which they must give every assistance. That view in our submission is unrealistic and does not reflect practice. The rare past references to Article 2.5 do not suggest that the General Assembly can impose obligations on members where none existed. Only decisions of the Security Council can do that. The word action, as opposed to cooperation, is employed in the Charter with particular reference to action by or authorized by decisions of the Security Council. This can be seen, for example, in Articles 11.2 and 24, and in Chapter 7, which is entitled Action with Respect to Threats to the Peace, Breaches of the Peace, and Acts of Aggression. While the General Assembly can make recommendations to member states, only the Security Council is given a power to impose an explicit obligation of compliance, as the Court noted in the Certain Expenses opinion. The drafting history of Article 2.5 supports this view. The Dumbarton Oaks proposals contained two separate paragraphs, which were combined at San Francisco without discussion. That suggests that they cover similar ground. Indeed, at San Francisco, one delegate stressed that the first limb of Article 2.5 should be understood to refer to action taken by the Security Council, as this was the only organ of the organization having authority to take action. That statement was not challenged by any delegation. This interpretation is supported by the virtually uniform and consistent practice of the United Nations and member states with respect to UN missions and staff. The latest edition of the Zimmer Commentary on the Charter, after an extensive evaluation, concludes that the practice, and I quote, supports the narrow interpretation which conceives the obligation to give assistance to apply only for enforcement measures under Chapter 7 of the Charter. End of quotation. Mr. President, members of the court, to be clear, the obligations of Israel as a member of the United Nations, of course, have to be read together with its obligations as an occupying power throughout the occupied Palestinian territories. And with that, Mr. President, I request that you invite Ms. Langrish back to the podium to discuss that matter. I thank you, Mr. President.
I thank Sir Michael Wood. I now give the floor back to Ms. Sally Langrish.
Mr. President, members of the court, I shall now address you on Israel's obligations under international humanitarian law as an occupying power. You have ample material before you on international humanitarian law, so I can be relatively brief. I shall conclude my statement by referring to the obligations owed to the International Committee of the Red Cross, a matter to which the United Kingdom attaches great importance, and which we suggest could be reflected in your advisory opinion. As is stated in Article 43 of the 1907 Hague Regulations, under the law of occupation, Israel, as the occupying power, shall take all the measures in his power to restore and ensure as far as possible public order and safety, l'ordre et la vie publique. This fundamental principle reflects customary international law and is elaborated on in the provisions of Geneva Convention, GC4 of 1949. Two provisions of GC4 are particularly relevant. Articles 59 and 55. I will address these in turn. Under Article 59 of GC4, Israel is bound to facilitate the provision of foodstuff, medical supplies and clothing into the occupied Palestinian territories. A number of points bear emphasis. First, Article 59 provides that if the whole or the part of the population of an occupied territory is inadequately supplied, the occupying power shall agree to and facilitate relief schemes on behalf of the population. Once this obligation is triggered, the occupying power is required to agree to relief schemes on behalf of the said population. That obligation continues to apply for so long as part of the population is inadequately supplied. A refusal to negotiate or agree to relief schemes will constitute a violation of Article 59. Second, the occupying power must facilitate relief schemes by all means at its disposal. This obligation is unconditional. Facilitation requires wholehearted cooperation in the rapid and scrupulous execution of these schemes. This includes the provision of transport, storage and distribution facilities. Third, relief schemes may be undertaken either by states or by impartial humanitarian organisations. In circumstances where the civilian population of the occupied Palestinian territory is inadequately supplied, Israel may not withhold consent to offers to conduct humanitarian relief operations that are exclusively humanitarian and impartial in nature. The United Kingdom considers that UNRWA is an impartial humanitarian organisation for the purposes of Article 59 of GC4. Insofar as impartiality is understood as meaning neutrality, UNRWA also satisfies that requirement. The Colonna report states that, I quote, since 2017, UNRWA has established and updated a significant number of policies, mechanisms and procedures to ensure compliance with the obligation to uphold the principle of neutrality, end of quote. The United Kingdom has made clear its serious concern about the two recent Knesset laws. We have reiterated our support for UNRWA's mandate to provide essential services and humanitarian assistance to Palestine refugees in the occupied Palestinian territories. At the same time, the United Kingdom has been clear that UNRWA should abide by the highest standards of neutrality and that any allegations otherwise should be independently investigated. The United Kingdom notes that UNRWA has adopted a high-level action plan to respond to the Colonna report's recommendations. So far, UNRWA has fully implemented 5 recommendations, including sharing staff lists with Israel and providing for a centralised neutrality investigations unit with international staff. The United Kingdom supports UNRWA's continued work and commitment to the principle of neutrality in line with the Colonna report. Any alleged involvement of UNRWA staff in the barbaric terrorist attacks of 7th of October 2023 and subsequent allegations must be thoroughly investigated. The United Kingdom expressed its deep concern in respect of Emily Damari, a UK national who was taken hostage on the 7th of October, and about reports that she was held in an UNRWA facility. The United Kingdom welcomed the UNRWA Commissioner General's call for an independent investigation into any reported misuse of UN premises by Palestinian militants, including Hamas. Overall, an occupying power retains a discretion in principle as to which states or organisations provide assistance. However, in circumstances where 1. The occupying power is unable to meet the needs of the population, 2. No other offer of assistance will be sufficient to render adequate assistance, and 3. The humanitarian need is grave and urgent, it would be incompatible with a good faith performance of Article 59 to refuse an offer of assistance from an organisation that has capacity. Such refusal will be incompatible with the obligation to use all means at its disposal to facilitate relief schemes on behalf of the population. Mr. President, I turn now to Article 55 of GC4. Pursuant to Article 55, an occupying power has a duty to ensure the food and medical supplies of the population to the fullest extent of the means available to it. Where the resources of the occupied territory are inadequate, the occupying power comes under an additional obligation, in particular, to bring in the necessary foodstuffs, medical stores, and other articles. This extends to bringing in supplies necessary for an adequate standard of living, including clothing, bedding, and shelter. Article 55 does not prescribe the method of compliance. What is essential is that the occupying power takes measures to ensure the necessary food and medical supplies for the population. This requires the occupying power to maintain at a reasonable level the material conditions under which the population of the occupied territory lives. It is open to an occupying power to procure the supply of food and medical supplies through a third party, including through a relief scheme under Article 59. In a situation where an occupying power decides to meet its obligations through a third party, such as UNRWA, the occupying power must ensure the safety and security of that third party as far as possible. In circumstances where an occupying power has failed to ensure the food and medical supplies of the population, a failure to agree to and facilitate relief being provided by that impartial organisation is likely to constitute a violation of both Article 59 and Article 55. This conclusion is reinforced by two obligations which both inform the content of Articles 59 and 55 and also constitute independent obligations. First, Israel is under an obligation under customary international law to allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need.
Excuse me to interrupt. Could you please speak slowly? Thank you.
Forgive me, Mr. President. Second, Article 55 requires an occupying power to allow protecting power to verify the state of food and medical supplies in occupied territories. That obligation can only be temporarily restricted for imperative military reasons. Restrictions are, moreover, only authorised as an exceptional measure and may not, at any time, be of a general or permanent nature. Finally, it should be recalled that Article 60 makes clear that the fact that humanitarian agencies are providing services and assistance to the population does not relieve the occupying power of any of its responsibilities under Articles 55, 56 and 59. Mr. President, members of the Court, as a concluding point, it is important to highlight the International Committee of the Red Cross. The ICRC plays a vital role in protecting the lives and dignity of victims of armed conflict, providing assistance and promoting respect for international humanitarian law. As members of the court are well aware, the law of occupation provides a special position for the ICRC that shall be recognised and respected at all times. With respect to visits to protected persons, this is spelt out in detail in Article 143 of GC4. Under Article 30 of GC4, protected persons shall have every facility for making application to the International Committee of the Red Cross. The right to be visited by the ICRC equally applies to protected persons charged with offences by the occupying power. Visits to detainees by the ICRC may not be prohibited, except for reasons of imperative military necessity, and then only as an exceptional or temporary measure. The exception is expressed in narrow terms. The provision applies equally to the hostages being held in Gaza. Mr. President, there have been repeated credible reports of ill treatment of Palestinian detainees held in Israeli custody since the 7th of October attacks. ICRC visits and access to those interned at times of conflict is aimed precisely at ensuring that they are treated humanely and with dignity, and to provide some information to their families and loved ones as to their well-being. It should be noted that neither the ICRC nor anyone else has been able to visit and access the Israeli and other hostages being held in Gaza by Hamas and other militants. Hostages released have shared horrific stories of ill treatment and abuse that may amount to torture. This also is completely unacceptable, but cannot serve as justification for Israel to deny the ICRC access to Palestinian detainees since October 2023. Mr. President, members of the court, in our statement today, we have aimed to assist the court by indicating our views on the question put to the court and on the obligations of Israel, both as a member of the United Nations and as an occupying power. Mr. President, members of the court, that concludes our oral statement in these proceedings, and we thank you for your attention.